मोअज़्ज़ज़ मेहमान हैं जनाब नज़ीर गिलानी साहब, ये जम्मू एंड कश्मीर काउंसिल फॉर ह्यूमन राइट्स के चेयरमैन हैं और मौजूद आज़ाद कश्मीर एंड UN के साथ हैं। Mr. Chairman, members of the committee, distinguished members of the judiciary, brothers and sisters. I have chosen entirely a different subject, and I shall be addressing to the facts, i.e. what is available at the United Nations for us under these circumstances. So I shall attempt not to digress from that. As I said, that what is available at the United Nations, and we are not taking it up. I hope you will bear me out on that. The Universal Declaration of Human Rights, Red Cross, Women, and international treaties have now dented into the doctrine that a state has a sovereign structure. No state in any part of the world can hide anymore behind the shadows of national sovereignty. There is now a new doctrine that has developed, which is humanitarian intervention. Whenever a state commits atrocities and shocks the international conscience, people have to intervene on the doctrine of legitimate humanitarian intervention. So the question is, have we been able to cling on to that doctrine? Have we explored the avenues how we can benefit from that doctrine? There is now a superior international standard which is established not by force but by common consent. So there is a supreme international standard. This standard is now used for judging the domestic laws and the actual conduct of sovereign states within their own territories and also in the exercise of their internal jurisdictions. So forget about it that India is India and the international bodies have no intervening opportunity. They can dent into national sovereign defenses. This international standard now ranks in the hierarchy of thought even and above national constitutions. So now I will come down to the right thing, that is that we have to concern ourselves and have to ask ourselves the basic question. And you have here distinguished members of the judiciary as well, who can steer this intellectual campaign, the legal campaign. That is, have we geared ourselves to involve human procedure, and have we triggered the humanitarian intervention? Neither the government of Azad Kashmir nor the people of Kashmir have so far tried to use the procedures available to us. We don't need to ask America for those procedures. There are procedures that you can invoke. Have you done so? That's the basic question. What can be done by the government of Azad Kashmir and her friends, even by groups and individuals? This is the basic question. Is it that we simply talk and without the substance? You have to sink deep into your heart and ask this question to your own conscience. Though it's very difficult for me to address this very noble audience, because I have here people from legal field who have a very eminent elevation and stature, but I will try not to shrink in courage. On 15th of January 1948, at the first meeting of the Security Council, settlement by reference to the people of Kashmir meant that the people of Kashmir became the subjects of international law. Both India and Pakistan, by common consent, conceded to a superior international standard. So they have, by common consent, agreed to accept an international standard. The ceasefire resolution on 13th of August 48, the appointment of UN military observer groups, the appointment of the cleansing administrator were in the context of the twin principle of universal inherence and inalienability of the right of self-determination. Article 1(2) of the UN Charter, it creates a specific obligation for India and Pakistan with regard to Kashmir. Not only there is a specific obligation for India and Pakistan, there is a universal obligation as well for other member states in this respect. So how far have we tried to reach out to that obligation? The Council Resolution of 21st April 1948, which was passed by 9 votes against none, has created a specific obligation under Clause 7 for both India and Pakistan. India not only has failed to honor her obligations, but on the contrary, it has introduced in Indian occupied Kashmir a law which is called pass law. It is a form of identification that is required by both genders of any age. It provides Indian Army an excuse to wade into houses at any hour of the day or night. This intrusion falls foul. Even with the Supreme Court ruling of India, there is a Supreme Court ruling in the case of Khalid Singh versus State of Uttar Pradesh. So even those situations can be invoked. The two governments, International Covenant on Economic and Social Council, International Covenant on Civil and Political Rights, declare the right of self-determination in identical form. So this is not acquired, nor can be transferred, disposed of, extinguished by any act or event. So somebody said that the train is locked in the basement of United Nations, of course, but no event can extinguish it or its effect. Its primary correlative duty falls on a state and their public authorities, not on the individuals. So if that is the case, what should we do? What effective remedies are available? Are there any or none? What is our track record on this? It begs our attention. So now I will precisely point to you, and maybe some people are in a good mood to pick that up, to use that procedure. The Commission on Human Rights, it's a very important competent forum. This commission is based on Article 68 of UN Charter and consists of 43 member states elected by ECOSOC. The commission is responsible, please remember this, the commission is responsible for the promotion and protection of human rights. Under Articles 55 and 56 of UN Charter, all states have an international obligation to promote and protect human rights and fundamental freedoms. Rights, by definition, are international and universal. Human rights, I mean. The Commission annually establishes a working group to consider situations of alleged gross violation of human rights, referred to it by subcommission under the Resolution 1503. So this resolution could have been invoked at any time by the people of Kashmir. An individual can do it, a group of people can do it, a lawyer can do it. This is a working group. So there is another group which is to work on enforced and involuntary disappearances. We have heard that people have disappeared from Kashmir, so you could have invoked that committee as well. You had to lodge an application, but carefully considered application, because to lodge an application as the United Nations, one has to consider it with a depth of intellectual